Okay, everyone. Again, thank you to our sponsors. Thank you, Johnny. I appreciate everything that you and Janice do and the great job that you do for our members. A couple of things. We're getting started with this class. The formatting of the classes are going to be a little bit different. As you've noticed, when you sign up, the class names have been changed. The content is basically the same, but we're trying to bring a different spin as far as making the class more appealing. The content is going to be juiced up a little bit so you can make it more applicable in your business. We are going to be doing hybrids where it is going to be in person and in online. If they are CE classes, the only way that you'll be able to get credit after June will be in person. So you'll be able to watch it, but you just will not be able to get credit for it. But again, we are going to try and change up the formatting, use Zoom that we had to use. Now we're going to use it to our benefit. So be looking for the classes that are coming up. We're going to try and offer quite a few classes. Just a commercial in next week, next Wednesday. I'm going to encourage everyone to take the showing time, not the showing time, HomeSnap. We have a corporate trainer from HomeSnap. So there's going to be a 2-hour training from 2 to 4. Please feel free to sign up, log in. There is no charge for this. And she's going to be able to offer a few more tips to the class on more than just searching. I'm sure she'll touch on how you can use it to prospect, how you can use it to share on social media, et cetera, et cetera. So put that on your calendar next Wednesday from 2 to 4. And then the following week on Wednesday, we're going to have showing time. That's going to be a corporate trainer, the showing time beginners. For those that are not familiar with showing time, please tune in for that from 11 to 12. And then from 1 till 2, we're going to have an advanced showing time class that talks about some of the features that you may not be aware of it. Also, there's going to be a CE class that's going to be offered, Code of Ethics. They're going to have a good instructor this time instead of me. It's Lee Brown. She is a national speaker, has a great presentation. This class is being offered to you free. You can attend in person or you can attend online. This will be one of the last times that you'll be able to get CE credit online. After June 30th, no more credit's going to be given to online classes. So again, these are just a couple of the education opportunities that are coming up. I'm going to encourage you to take advantage of all these. Also, those that know me know that how much I depend on Abby Johnson. She's going to be taking a bigger role in the education, and I'm looking forward to that. Again, for those that don't know, we're good cop, bad cop, and it's not hard to tell who's the bad cop. So again, don't make her mad, but I'm looking forward to it. So with that, let's go ahead and get started. Again, I am really excited. Any questions that you might have, please feel free. If you're online, type it in. Class or people, just feel free to, we'll stop the class and go from there. Hopefully you are seeing my screen on online. I'm going to open up the documents. We're going to get into the sales contract, and the sales contract, the finance sales contract is, everybody wants to get to this point. You are basically writing instructions for the single largest financial decision that a buyer and a seller are going to make. Buying a home, people are making a 30-year investment. Whether they stay in it 30 years or not, that's to be remain to be seen. But the fact is, at the time, that's going to be the single largest financial investment that they're ever going to make in their life. And you've been trusted to help them make that decision. And if you're marketing a home, remember that that's more than just a house. It's a home to somebody. So I want us to be able to go through, because a lot of people have some misconceptions about what the contract says and doesn't say, and what it actually, things that you write in there that may be detrimental to one party or the other. So what we're going to do is we're going to go over it. Again, please feel free to ask any questions, and also always talk to your broker. Your broker is going to have the final say-so in how you write the offer up. And there's some things that they're going to want written in there. I'm not here to say that's wrong, right, or indifferent. I'm here to just go over the contract. I'm going to bring up some things, some clauses that are commonly written in that do not need to be written in. So what we're going to do is we're going to jump in. People forget, and I'll start with the basics. A lot of people like to say, I wrote 3 contracts last week. The fact of the matter is nobody writes a contract. The buyer's agent writes an offer to purchase. It's on a finance sales contract, which is pre-printed. There's a lot of time, hours, and effort that is put into getting this verbiage correct, but you don't write a contract. It's really very complicated to write a contract. So if you're working with a buyer, you're writing an offer to purchase. It does not become a contract until both buyer and seller agree, have a complete meeting of the minds. Then you have a contract that you can work off of. So my number one suggestion is use the pre-printed contract as much as possible. The written word trumps the printed word. So anything that you write in there that it contradicts or changes something in the contract, you're changing the whole face of the contract. So remember, you write an offer to purchase. It does not become a contract until there is a meeting of the minds between the buyer and the seller where everybody agrees on all the terms. So with that, you have to remember also that you have to have certain elements involved before it becomes a contract. You have to have a legal objective, which is basically the house. You have to have legally competent parties. And sometimes people think that's what excludes licensees from being buyers and sellers, but the buyer and the seller have to be legally competent, of legal age, and also have the power to sign. So if they're buying for an estate or if they're selling for an estate or something, they have to have the legal authority to sign legal documents. So those are the elements of a contract. Have to consider the element, and you have to have legally competent parties that are under no duress for this. So again, I'm going to go over some of these key paragraphs, talk about some tips, and I'm going to emphasize a couple of things that you do not need to write in there, and then we'll, again, stop at if you have any questions. So as we go into the pre-printed final finance sales contract, I'm just going to go over this. Again, remember, you're writing an offer, you're not writing a contract. First line, make sure you put the legal name of the purchasers. Don't put nicknames, don't put anything, because what will happen is it will slow the process down. They'll have to do an affidavit. So say that Michael Sandoval is known as Mike, Mikey, whatever names that I have. Make sure you use the legal name on that. And it says that they agree to purchase. Make sure you put their legal names complete, put both names in there, not necessarily Mr. and Mrs., because sometimes they have different names. So put the complete names. That's just a suggestion. So yes, ma'am. If there's going to be a power of attorney, that comes in the signature. The question was, if there's a power of attorney involved, what do you write in? And like for the sellers, you will write their legal name of the seller. If it's John Doe that you're the attorney in fact for, or the power of attorney, you will write John Doe. And then on the signature, you will write John Doe by your name, AIF, attorney in fact. And the attorney will tell you exactly how it needs to be spelled out. So the legal names still need to be in there. You're going to be signing. If you have a power of attorney, and that's a great question, if you have a power of attorney, you are signing the name of who you've been given the power to sign for. You'll have by your name, and then whether it's attorney in fact, power of attorney, whatever they tell you to write afterwards, that's what you're going to do. Some attorneys allow AIF. Some people make you spell it all the way out. So again, whichever way that you're told, that's going to be in the signature. But the legal names for the buyer and the seller go into those names, okay? Yes, ma'am.
Years ago, they used to make us put a single person if the person's not married. Do we still have to do that?
Question was, if is something that, if it's a single person, if it's Mike Sandoval, a single man, or, John Doe and Jane Doe, a married couple, that's a great thing to do that way, because when the deeds are written, there's a right of survivorship, and if they don't know that there's a wife in there, a lot of people, there may be one person, and that's one misconception. If one person's on the mortgage, there's still going to be two people on the deed. So you have to talk to the attorney. A lot of times that people think if only one person is doing the financing and they wrote the offer to purchase, it became a contract. At the closing, you're still going to need two people there, because if they are married, there's the wife or the husband, whoever is not the party that's written on the sales contract, still has a right of survivorship on the property. So that's a great question. You can't ever go wrong. Again, if it is John Doe and Jane Doe, a married couple, that's a great, because it clarifies for the attorney. Also, if it's Mike Sandoval, a single man, write that in there, and that way you eliminate that. Great question. All right, so then we're going to go through, and the verbiage talks about what's going to convey with the properties is describe real estate together with all improvements, shrubbery, plantings, and appurtenances. And that's one of the nice things. Appurtenances are always changing, but here is the verbiage basically saying that everything with the house that you see that's not personal property, we'll go into some details when we go into the body of the contract, is to remain with the property. If there's any personal property to remain with it, is sold as is and at no value. And that's for the mortgage company, because a lot of times there would be personal property that was left there that could be carried off. The mortgage company is not loaning money on that personal property. Address, city, county, state, zip, lot, block, subdivision, addition, and legal description. With everything that we have, I'm going to encourage you to put as much as you possibly can in there. If you're selling in a non-platted subdivision, it's going to say legal description. It's going to be meet and bounds. The problem is you can go into the tax record and it looks like the complete legal description. Sometimes it's not, but if you want to copy and paste when the attorney does their title search, it may become a little bit more extensive. But a tip, if there's a blank there, don't leave it blank. Put something in it. If it's a date, don't put to be determined. If it is, if it has an expiration date, put it in there. If it has a certain amount of days, put it in there. We're going to go into the next one, and it's talking about the financing. I'm going to give you some tips, but always talk to your broker. So again, if there's a lot, block, subdivision, make sure you put that in there. It makes it so much easier for the mortgage company and the attorney when they're doing their title search and they're doing their all the paperwork. Total purchase price. Now, this is the purchase price that we're starting with. Yes, I am well aware that we are in an insane market where prices, whatever you write on there doesn't mean squat. We have sight unseen, we have escalation clauses, we have buyer bonuses, where the seller bonus, where they have 24 hours to, I'm well aware of all that, but you have to start with a price, and that's what this price is going to be. If there's any amendments and any changes to it, that's why if there's a contract or an offer that's written, any addendums or counter offers have to be submitted. The days of saying, well, I'm going to write this so the mortgage company doesn't see it, those are gone. Don't do it. Any pieces of paper that's affiliated with this transaction, you make sure that the attorney and the lender gets this, because you start off with a price, $300,000. It may end up being $335,000, but if they have no record of that, then they're going to base everything on $300,000. So make sure that all paperwork is turned in, but you have to have a purchase price. Make sure the purchase price is here. Earnest money to be held by the selling company working with the purchaser, or can be the listing company. If it is somebody outside the real estate transaction, it needs to be stated in the body of the contract, because Alabama license law says that either the listing company or the listing broker or the selling broker have to hold it unless relieved of that duty in a written disclosure, which is generally done in the purchase agreement. So again, a lot of companies are not wanting to hold earnest money. If there's going to be somebody else, make sure that you put that company in there and you put it in the body of the contract. Here's a commercial. Be very careful about having other companies holding the earnest money, simply because there is no control. If you're working with a purchaser and there's a title company that's holding the earnest money, it could be conceivable that if the transaction doesn't work out and the seller says, I'm going to get the earnest money, They don't have to work with an earnest money release. They're not bound by Alabama license law as the brokers are. So the earnest money can end up in the wrong hands. So be very careful. I know a lot of brokers are wanting to relieve themselves of this responsibility. I understand it, but just be very careful that if an attorney or a title company or somebody holds it, they're not bound by Alabama license law. So there could be an issue with the releasing of the earnest money. Okay. Any questions or comments? And any comments have to be about the material, not the presenter, because he's very sensitive. Okay, we're going to get into now the contracts contingent upon. Make sure you put that blank in and you put the exact type right here of the of the type of financing. Simply because it used to be in the day and time where somebody would write an offer and it said this offer is contingent upon financing. Well, if I'm buying a house and I want a USDA loan where I don't have to put any money down, and they say, you know what? You don't qualify for that, but you do qualify for a conventional loan putting 20% down. I didn't want to put 20% down. But the fact is that if the contract said it was contingent upon financing, legally, I would be obligated to go ahead, and the mortgage company is not going to write a rejection letter for me stating that I can't get financing because I can. It's not the financing that I want. So for the protection of your purchaser, make sure you write in there the type of financing that they're going to get. And then for the loan amount of, this doesn't have to be exact because there's no way to get an exact loan amount. It's going to change depending on what day of the week that you close on, what day of the month, when it happens, mortgage, interest rates, per diems, et cetera, et cetera. But you just put in there if it is $300,000 and they're going to get a 90% loan, use your phone, type it in there, know that they're going to get a loan for $270,000. They're going to put $10,000 down or $30,000 down, and you rock on from there. But make sure that all these are filled out with some numbers. TBD does not work. Yep, the comment was made. TBD doesn't mean anything because when you have the listing and you're presenting a net sheet to your seller, you don't know what TBD is going to cost them. If there's some non-allowables, you don't know if it's going to be a high-risk loan. You don't know if it's cash. You need to put in there what it is. So that way, when you're presenting the offer or when somebody's presenting your offer, they know exactly what type of financing that they're going to be getting. Great question. Thank you.
Change through the
Yes, now it can change, and that's a great point. Thank you. If you go from that and it's going to change, let's say that I couldn't get the USDA, but I can get a 95% conventional, and I say, okay, that's good. I'll do that. We can write an addendum that says the loan type is going to be 95% conventional. Both parties sign, and we can rock on. Anything that's written in the sales contract, remember, can be amended and changed. Anything that's put in there, everything in real estate is negotiable. But just remember that if you write something that changes the language of the contract, it's hard to unring that bell. Can't do it. A great question. It can change during the financing can change. All right, it says the balance to be due from the purchaser, either wire transfer or certified funds. Make sure that you put purchaser agrees to apply for said loan within X amount of days because that's, and we'll get to the binding date on the back of the contract, but they have a certain amount of time, an obligation once you get an accepted offer. It's ripened into a ratified contract. Then now everybody's responsible for certain timeframes, and the purchaser is going to be the first one. They have to make a formal loan application within X amount of working days. Make sure that's filled out. Settlement charges in here, if there were any settlement charges, and notice the verbiage is settlement charges, not closing costs. Settlement charges includes loan closing costs and prepaid items. Anything else, if you had closing costs, they may exclude the prepaid items or the escrow items, things like that. Settlement charges, and make sure that dollar amount is to be filled out. If there's a funding fee to be financed, please put that in there. Mark that box, yes or no. Your lender can give you the answers to this. All right.
Hey, Mike,
Yes.
don't forget about BHA loan disclosure.
Yes, it's written in there. The mortgage company on a FHA loan or VA loan, there's going to be a disclosure addendum that's going to have to be typed in. Make sure that you do that. but I've got a lunch and learn coming up, and we're going to talk about some of the addendums that are required. The class time does not permit me to go into that, but that's a great point. Make sure that you notice and you check with the lender if there's any other addendums that have to be assigned and submitted with the offer. They will let you know what it is. But thank you. Great point. All right. Surveys. Now, surveys are something that a lot of people don't write in. Check with your broker. Rule of thumb was if there is meat and bounds, you get a survey, because in days and times, something may have started off with 10 acres, but then the owner said, well, I'm going to give my child an acre, and they don't record it. They just build on there. And then the points of the land was, well, my land runs from the oak tree all the way back to the well, goes over to the corner to the barn, and right over here to the tree stump, and the barn burns down, the well dries up, all of a sudden you don't have any points there. And you'll be surprised how people get real testy over a couple of feet. No, that's my property. No, that's my property. So meat and bounds, go ahead and get a survey. A lot of times people don't want to have a survey done in a platted subdivision. Check with your broker. There are times where you have replats of 2 lots. And sometimes there may be a mix up in that. You can always ask the surveyor to do where they can mark the corners. Again, something works, nothing doesn't. If you can, go ahead, just make sure that you're protecting yourself.
The seller, purchaser wants the seller to pay for it, write it in.
Exactly. If the purchaser wants the seller to pay for it, write it in. Again, great point. Everything in real estate is negotiable, but make sure you put who's going to pay for what. It would be in the additional provisions. Right. The question was, where would you write it? It would be in the additional provisions. All right. Conveyance. This basically says that the seller is going to convey to the purchaser a general warranty deed free of any liens or encumbrances. The only real exception that I'm aware of, sometimes you get into special types of deeds. The most common type after the general warranty is going to be a special warranty, but that only occurs on foreclosed properties. A seller of regular arm's length transaction cannot convey title with a special warranty deed. Only banks can convey title with a special warranty deed, because there's a period of time where they can't guarantee the title and they're excluded from that. But again, that's going to be the type of title that's going to be conveyed. Title insurance. Again, this is the one thing that people don't understand. And when you're doing an estimated settlement chart, closing statement, people get freaked out about it. Basically, you're insuring everybody, and the premiums are getting split. There has to be protection. The seller may think that they were conveyed clean title. They're going to convey the same title that they have, but if in the title search something else comes up and there is no title insurance, the only people that profit from this are attorneys. So in the transaction, there's going to have to be a guarantee to protect both the buyer and the seller, and that's going to be owner's title insurance. Now, the borrower in the closing costs, you'll notice there's more title insurance, and that's going to protect the lender, and that's part of the closing cost. But again, title insurance is going to protect the buyer and the seller, and both of them agree to split the policy in half. Any questions about that? Okay, closing in possession. Again, I'm going to give you what is the most common. That's probably the least dangerous. However, if there's any exceptions to this, check with your broker. Never have your broker find out from somebody else besides you that you've got an issue on your transaction. So you make sure you keep them in the loop. But closing in possession, when the transaction's closed, possession generally takes place at that time. People think, oh, that's understood. No, it's not, because there was a day where sellers thought, well, I've got 30 days to go ahead and pack up. And so basically the mortgage company was thinking that somebody was living in the house and they have renters in there. There's a lot of liability that can occur. And I've heard of cases where you either have early possession or the seller gets possession after closing and something happens to the house. Well, the mortgage company doesn't care about that piece of paper. All they know is prior to them lending money, the seller owns it. So if the buyer moves in early and if there's any damage, somebody have a question? Okay. If the seller is going to gave the buyer early possession and they burn the house down, guess what? There's no closing to it and the seller's going to be in trouble because their insurance company is going to say, sorry, you were renting the house to someone and we're not going to pay. So you're going to have a mortgage company for the seller that's going to say, your loan is due right now, all in full and payable. Generally, they don't have the money, foreclosure. If somebody goes ahead and allows the seller time afterwards, the mortgage company of the buyer thinks that the buyer has it. The insurance company thinks that the buyer's living in it. If there's 10 days afterwards that the seller has possession and they burn the house down, the mortgage company's not going to go after the seller. They're going to go after the buyer. Their loan amount's going to be due and payable, and the insurance company that they had is not going to pay it because they weren't living in it. So be very careful about the closing and possession. We automatically assume that it's going to be at closing. Sometimes people write exceptions. Don't unless your attorney, unless your broker knows. Sorry. All right, number 3, agency disclosure. Make sure you fill this out. The listing company is. Now, if you are working with the purchaser, do not assume that you know how the listing company is representing the seller. Do not check the box for them. If you are writing the offer, and that's how we're looking at this piece of paper. You are the selling company. You check the box that you are responsible for. If you're going to be an agent of the purchaser, click, you check that. If you are representing the purchaser as a transaction broker, you check that. Now there's a lot of questions because in parentheses it says 2 boxes may, or 2 blocks may be checked. It doesn't say that 2 have to be checked because a lot of people get all caught up in, well, it's my list, my sell, and I'm representing both parties in the transaction. So on this side, I'm an agent for the purchaser and I'm a limited consensual dual agent. You're not, because that makes you 3 agents. And in Alabama, they allow dual agency, not triple agency. If you are a limited consensual dual agent, you cannot be an agent for the buyer or the seller. You are an agent for the buyer and the seller. So if you check that box that says agent of the seller or agent of the purchaser, you're incorrect. You're either going to be a limited consensual dual agent or you're going to be a single agent on that side. Yes, ma'am.
I've had issues with Dotloop,
Mm-hmm.
not filling out the box.
Mm-hmm.
Then you go and everybody signs it, and then they want to go back and change it, and then it removes all the signatures.
It does do that.
So, I mean, I always said, call and find out what the company is.
That's why personally I'd leave it blank because when they go, because you don't ever know how they're representing, make it fall upon them. Because if you make the changes, then you erase all the signatures on there. They're allowed to check and do this and they can go
Yeah,
ahead.
that's what I'm saying, but I'm the buyer's agent,
Mhm.
and I don't know what the listing agent is.
Mm-hmm. If they check the box, yes, they're going to go ahead and most offers are not
So
accepted.
my signatures are, but they go and add what they are.
Right. If there's an acceptance of the contract, maybe, in this day and time, nobody accepts the original offer. There's always going to be a counter or something like that. Great point. I'll talk to Dotloop and see. The question was that if you're the purchaser and you submit it and it's blank on the listing side and the agent checks, if the offer's to be accepted, it wipes out the signatures. That's a hiccup in Dotloop
And I
and
understand that you're changing something after somebody signed it, but you're gonna check that box after the fact that this is what
Once you
you need.
email it to them, though, they're not, they can sign it. Right?
But
It should
that's-
erase your
But
signature.
what she's saying, if.
that's
she
why y'all need to be
would not
here.
check
Great
that,
conversation going on about Dotloop right
And,
now.
they check.
So,
it,
and if anybody out there knows, the scenario is, I've written an offer, I send it to you. I do not check the listing company as an agent or anything. If the listing agent clicks that, does it take away the signatures?
I know, and that's why.
What say you out there
Once you
in
email it
Zoom
to
land?
that other agent, then they could fill in their portion,
That's why I'm-
and they could assign it to their seller or
But
buyer.
if they
And it
check
shouldn't
that
be.
box and you have not checked, it's what she's saying, it
Yeah.
wipes out everything.
Okay, Samantha says yes, so I will address that, and that's a great point. A way to alleviate that, you can go ahead and call the listing company and find out how they're representing. You might be right in in checking, because most people represent the seller as a single agent, and that's fine. But again, maybe something can be brought up. That's a great point. That's a hiccup in dot loops, but you can always handle the exceptions. Sometimes you can, if you want to add a little checkbox there, they can do that. Great.
So if you're dual agent, you would check, and I represent the buyer, well.
The question was, if you have an agency relationship or if your brokerage is representing as a limited consensual dual agent, there's only going to be one box that's checked, and you are representing the buyer, seller, and the purchaser as a limited consensual dual agent. So it's just one box. Now, the only time that two boxes may be checked is if you have a transaction brokerage agreement with one of the parties. Case in point, I'm working with a buyer. I'm going to sell it for sale by owner. Now, a lot of people go ahead and try to establish agency relationship with a for sale by owner. That's like getting married before you date. Don't assume that liability. You can represent the transaction as a transaction broker for the for sale by owner. They get everything that the recad says on there, but you do not have fiduciary responsibilities to the seller, because the seller's already said, if this transaction, I'm going to go ahead and put it on the market for sale by owner again. So as a, if you're representing that seller in a for sale by owner, you're representing that seller as a transaction broker. So on that listing side, you would be checking, you're an agent of the purchaser and you're assisting the seller as a transaction broker. Let's say that you have an open house, you have an agency agreement with the seller. Somebody comes to your open house and says, I'm going to, whoever the listing agent is, I'm going to submit an offer. If we don't negotiate it, then I'm going to go to the next listing agent. Again, why establish agency relationship with a purchaser that's not going to be loyal to you? You represent them as a transaction broker, so you would check the two boxes. Agent of the seller and representing the seller, or agent of the buyer and representing the assisting seller as a transaction broker. That would be the only time that two boxes would be checked. Questions or comments? All right, in this day and age, you call in the listing agent. Melissa, that's a great point. And I've got to pay better attention. Thank y'all for participating. It takes away the signature. You can download it and bring it back in the dot loop and add a checkbox. That's another way to alleviate. Yeah. And in this day and time, you can call the listing agent prior to the offer anyway to find out how to win, and you can find out how they're representing, so you can go ahead and do that. Great point. And one of the things, you can't have too much communication with the agent. You got to remember that, as I said before, you got to have a buyer and a seller. The two licensees that are involved, it's really a privilege for you to be involved there, because you can take any one of those two and interchange it with two other people, and a transaction will close. Take it as a privilege. It's not owed to you. Take it as a privilege and make sure that you make it. If you're working with the buyer, it's about them. If you're marketing that home, it's about the seller. And make sure that you cooperate with the other licensee. The sum of the total is always greater than the individual parts. Is a transaction broker entitled to some part of the commission? Great question, and the answer is yes. For any property to be entered into the MLS, there has to be a commission paid. Now, here's a commercial, and there may be somebody out there that has this and is doing it. They're sitting in the class for it. You want to call me? We'll discuss it, but I have an opinion. As for those that don't know, I was a realtor for 20 years. I've been in rehab for the last 4 that made me put my license inactive, but I still am a realtor. And one of the things is I see in the transaction or the compensation that an agent is offered 3% and a transaction broker is offered 2.5%. And sometimes 2%. You know, part of the thing is the seller and everything is negotiated, but a lot of times if you're the listing agent, don't be guilty of this. You go ahead and make that decision for the seller. Number one, by saying you're going to offer a different amount of compensation because you say they don't do as much in the transaction. I'm going to counter that with saying they have responsibilities to that. They do not assume some of the liabilities with the buyer. That's the only thing that's different. Your seller doesn't become more liable or less liable. They don't have to do more work or less work. Plus, if you are not compensating, if you're saving that 1%, are you truly giving it back to the seller? Because a lot of people go ahead and say, we're paying a 6% commission, but I'm only paying a transaction broker too. That means that the seller, or the listing agent, has now gone from 3 to 4. Or if you're working with, you got the listing and you're working with the buyer as a transaction broker, do you penalize yourself that same way? Now, I understand, but a lot of people don't realize that the Alabama Real Estate Commission says it is legal for a transaction broker to sell property. Just like Lisa asked, is a transaction broker entitled? Absolutely. And again, if you want, we can discuss this. The only thing that an agent does is assume more liability. Doesn't mean that they do any more work or less. They have fiduciary responsibilities to their buyer. If you are working with a seller, that does not increase the liability to the seller. That was a commercial. Didn't have to pay for that. People up here, they don't let me speak. But the thing is, and see, that's where the people that are not here, not only did you get a breakfast, you got to listen to me preach in person. All right. So we're going to go through, we've talked about that. Remember right here, there's a receipt of the real estate brokerage services disclosure, otherwise known as RECAD. Remember, you have a responsibility to present this. Not only that, .loop makes it super easy to go ahead and say, click here, here, here. But you have a legal obligation to explain all this to the seller, to the party you're working with. We're working with a buyer. One of the things that I want you to know is they can read. You need to be able to present this in layman terms, explain it to them where they can understand it. They can read what title insurance is. You explain to them what it is. That's why we're having these classes. And I'm falling behind, so I'm going to sort of breeze through this. Condition of the property. And again, please feel free to ask any questions. Condition of the property. This says, this is the infamous 4A. This says the seller agrees to deliver all built-in appliances, heating and cooling, electrical, gas, plumbing, and septic systems in normal operating conditions. Doesn't say has to be brand new. Does not say that it has to be above, if it is within the normal parameters, if it is in normal operating condition, the seller has met their obligation. So again, remember that any systems, any heating, cooling, plumbing, and electrical, the seller agrees that everything is to be in normal operating condition when title is passed or possession is given, whichever occurs first. The purchaser has that responsibility to make sure, caveat emptor. That's what the home inspection has done. That's why we're doing it. All right, so any questions about the condition of the property? Yes, ma'am.
If they're selling it as is, does 4A still apply?
As is means the way it is when they look at it. So it may apply, may not apply, but there's not an obligation to the seller to make sure that it's in normal operating condition. If it was not operating at that time, they don't have to bring it back.
And they don't have to turn the utilities on.
They do have an obligation to have the utilities turned off. That's a separate thing. The question was, number one, does 4A apply to property as is? And as is has big meaning for being such little words, but as is means at that time. So if it's not working at that time, the seller doesn't have an obligation to bring it to spec. She also talked about having the power turned on. That's something separate. It says here that the seller has the responsibilities to have the utilities turned on and to maintain utilities through the date of closing. That has an obligation because, if it's not working, that's fine, but you still have an obligation to have the utilities turned on. Okay.
If you turn the water on and there's a busted pipe or a leak.
Right.
Well, you do your final walkthrough.
You don't want the water on.
No, a lot of times they turn them off on purpose.
Right. So
And-
are you obligated then if you know there's?
Again, it's going to depend on the financing in a lot of it. The things were, as far as the utilities, there's an obligation to have the seller turned on. If it's off, and sometimes the purchaser doesn't never want it turned on. Again, but mortgage companies are going to require, depending on the type of financing that you're getting.
The reason the investors get so many of these, they don't care.
4B is the lead-based paint contingency for pre-1978. Remember, this is not just an association. This is not a state. This is a federal mandate. So if the property is built prior to 1978, make sure you fill this out. There's dates in there. Generally, it's going to be no more than 10 days that they have the opportunity to have a lead-based paint inspection. There are companies out there. It's very costly, but I've actually had people to do it. So just make sure that you know that. Question was, what if it's a distressed property, vacant, and utilities have been on for quite some time? Then they have to be maintained. If the buyer walks in and the utilities are off, generally it's going to be a cash. If it's any type of financing, that's not going to happen. They have not been on. Okay. Again, if a property sold as is, generally it's going to be just like that. A lot of times I've seen investors or purchasers put it in their own name to have it turned on to see if something's working, but the property is as is. Again, if the utilities are on when they come in, it's as is. The utilities have to stay on during that time. How much does a lead-based paint inspection usually cost? They can run upwards from $1,000 and going up from there. So it is but again, the purchaser has the right to have that done. Great question. All right, so then we're going to go through there. Remember that there are 2 places to be initialed. UDOT loopers. If you have them and acknowledge that they have received that pamphlet, make sure you UDOT loop them the pamphlet, because if not, you're having them sign saying, I got something that I really did. Don't be that person. Okay, the wood infestation report. Purchaser may obtain at his or her expense unless it's not allowed by VA guidelines. And again, check with your lender, because those sometimes change now that they're the non-allowables sometimes can be allowables, but again, only the lender will be able to determine that. My pleasure, Samantha. Thank you. All right. A lot of times that, a wood infestation report is only good for 30 days. Remember that. Also remember that it has to be presented to the attorney no less than 7 working days. It's in the contract. So don't wait until the last minute to get it in there, because you could hold up the closing on that. Questions, comments? Jenny?
No, I just don't.
Okay.
But I have a bunch of counties.
Okay. And again, that's a great point. What we're doing is I'm going over the Huntsville. If you use another one, please make note. It was brought to my attention that Marshall County says 5 days, and that's great. There's going to be a different time frames in there, but the basic verbiage of those paragraphs are going to be the same. Yes, ma'am.
In Marshall County, when it says purchaser will get an AWI, but in the lender's design, y'all don't have to have it.
Mm-hmm.
You put something in the addendum saying everybody agrees you're not going to get one.
That's a great point. It's put in there that the contract or the offer that there's going to be an Alabama wood infestation report that's going to be done. If they choose not to, I will write an addendum stating that this has been waived. This requirement has been waived by the mortgage company.
Norfolk too, the whole conference, so make sure the lender's okay with that.
Yeah.
That deals were.
Well, it was, that was the lender that said, no, you don't have.
Remember that you're working very closely with the lender on this, so you're following their instructions as much as you are anybody else's. Because if the lender says thou shalt and you say thou shalt not, they usually win because they're not going to fund it. And unless you have the money to fund it, generally it's not going to happen. I want to spend some time right here with the additional property inspections. Again, there is notice here that there says there is an inspection addendum that is attached. Use that. Do not, number one, do not write anything in the additional provisions addressing property inspections. Do not. If you do, you make sure your broker has signed off on it, because what you are doing, remember, the printed word is trumped by the written word. So if you write something in there and there's a clause that makes everybody's head spin, and that is, this offer is contingent upon a satisfactory home inspection. What is satisfactory? We've got 20 people in the class. Actually, we got 26. Thank y'all so much. But you're going to have a difference of opinion on what satisfactory is. The inspection addendum is written very precisely, gives rights to the buyers and the sellers on how to address They have so many days to have an inspection done. Then they have so many days to put requests for repairs. Then there's so many days for a response. And then if the response is not a complete acceptance, how that's to be handled. So again, do not trump that by saying satisfactory home inspection. If you do, make sure your broker knows it, because satisfactory is different to everybody. And you're writing instructions on a purchaser to void the offer, just like that. Don't do it. Don't be party to that. Let the verbiage speak to itself. Yes, ma'am.
I use a husband or contract a lot. 'Cause I like
Mhm.
to but Marshall County does it.
If
A
you're
lot of people write that in.
If your home inspection, if the contract that you generally don't use, that you use does not have that, use this. The only thing I would tell you to do is make the corrections on the paragraphs, because there's paragraph 4A or 11A, whatever it is, that refers to the right to have a property inspection may be different in another sales contract. So that would be the only change, but you can use this given the same time frames or anything like that.
As
Yes,
a
ma'am.
listing agent, can you tell your clients not to accept it if they put all this verbiage in there?
Absolutely.
Because I've had them try to walk away, but even after the inspection found nothing that was in the inspection addendum.
Case in point, if it is your listing and you have satisfactory written in the additional provisions, you have the right to have it countered. Do not, you can say you will go per the terms of the inspection addendum, but do not, and again, if you're going to allow that, make sure your broker knows it. But if it's your listing, you are basically giving the buyer the right to walk away with no ramifications.
They'll do it.
All right.
They write that in.
Yep.
Yeah, they'll get cold feet and walk away and want their own estate.
When you say, there's a question from Christina that says, when you say I need to get my wood infestation report to the attorney, is adding it to the loop sufficient, or do I need to email it to them directly? Directly to them. An attorney and a lender can be included in the loop. It's always a good thing to do. They can be given the privileges to sign on, to view only, and then you can take all the documents there. I'm going to beg indulgence for about a minute and a half. I've got to log into another webinar. This class is going to run over, so I'm going to cheat. Don't tell on me.
I tell myself that it's like, I'm thinking that they made, so I'm thinking that they have that fault that. You can also explain it to.
Yeah, well,
It could be that way, but please explain to yourself.
exactly. But satisfactory, they can interpret it any way they
I
want
understand,
to. It's ugly.
But if all the other terms
I'm
agree.
trying to think what that's what satisfactory is. Think it to-
I reject the kind of,
But see, like I said, Marshall County doesn't have a-
I reject it. I reject the kind of, it was on more, I said, no, I'm not,
Well, I have dealt with it and we have fought big time over it.
no. that's what-
Because we accepted their contract over somebody else's, and then they decided they got cold feet. And so
All right, thank y'all so much for this. But again, this is the number one most abused clause in the contract, is the additional property inspection. There's a lunch and learn, I think, scheduled for the 24th, somewhere around there, that I'll have more time to go into these. Please make it, I'm not the best, but it can be so informative. If you pick up something that helps you and reduces your risk, then it's all well and good. So please do that. Look on your calendar, look for the lunch and learn in June that says forms and addendums. Please try to attend to that. But again, the property inspections, make sure that you let the addendum speak for itself. An addendum is like the pre-printed contract. There's a lot of hours, a lot of experience that's been put into write that. So make sure you let it speak. Anything that you write trumps that. Satisfactory home inspection is a no-no. Do not do that. If it is your listing, make sure you counter that. All right, property inspections, that's covered. C is your escape clause. Basically, that says that neither the seller nor the licensees make any representations or warranties about the condition of the property. It is the way it is. It's up to the buyer to have any inspections that they want done to verify and put their mind at ease at how the condition of the property, whether it be radon, whether it be septic, whether it be whatever inspection that they want. They have that time frame to work under to get it done and then be satisfied with it. Now, remember, Alabama's caveat emptor, buyer beware. That does not mean that the buyers don't have rights. They do. It's just upon them. Remember this also, if you are a buyer's agent, caveat emptor does not apply. You take that away, you assume that responsibility with your fiduciary duties to the buyer. So remember that. We'll get into that in an agency class. All right, so again, what C is your get out of jail free card. You're telling them you are not an expert in any of this. You stay in your lane in real estate. You're not a home inspector. You're not a wood infestation report. You're not air conditioning, foundation, anything like that. So don't try to be. Final inspections. This says within a certain period of time, before the closing of the transaction, the purchaser has the obligation to go through and make sure that everything is working. Referring back to 4A, all the systems, the heating, cooling, plumbing, electrical, make sure they are good operating condition, because remember, once title is passed, it is theirs. All right, the disclaimer, this just says you have not relied on any of the licensees involved for the condition of the air conditioning, for the wood infestation, for foundation. All you have relied on the real estate licensee is real estate experience. So that's what the disclaimer is. Know that. Again, remember, we're going over this to have you understand it so you can present it in a way that they can understand it. So that disclaimer tells you that you are an expert in real estate. You are not an attorney. You're not a lender. You're not a home inspector. Don't try to be. And it gives some conditions, talks about the age, square footage of the improvements, et cetera, et cetera. That's upon the buyer, and the buyer may ask their agent to do that, to verify that information. It is up to the agent. But that is your disclaimer saying that neither one of these have relied on the information given. This talks about the financing, the different types of financing. All that's going to say, if FHA's financing is used, the attached disclosure is incorporated and becomes part of the contract. It is in your documents. Make sure you become familiar with it. VA financing. Remember that VA is the only thing that says if it does not appraise, the purchaser gets their earnest money back. Only time, because the government is not under license law. The government can go ahead and say that. So remember that in a VA loan, and you can check with your lender, a VA loan says, if it does not appraise, let me see, then the transaction can be voided and the earnest money can be. Doesn't say must be, says can be. Everybody can renegotiate, as we talked about earlier. If you have a certain price and the property doesn't appraise, but both parties agree that it's only $100 off, we're going to go ahead and rock on. You type an addendum and everybody moves on. Doesn't mean that it, just because it can mean it has to be.
What about that phrase, putting it in the divisions about,
Again,
if it doesn't appraise, if it's not a VA?
That's the second clause I'm going to get into. That is a bozo no-no. All right. It says Robert asks, can someone refresh me, but is it an additional clause or addendum where the price can be renegotiated upon an inspection, even if it is as is? Remember, and this is another point, great point. It talks about the price being renegotiated. Nothing says the price is renegotiated. I'm going to tell you, don't renegotiate the price. Because what's going to happen is, if I'm working with the buyer and I say, oh, in lieu of these repairs, the sales price is going to be reduced $10,000. Everybody agrees to it. That's fine. But guess what? 6 months from now, that repair that needed to be done isn't done. The system goes down, and that buyer is going to say, my agent told me to renegotiate the price. It has happened. Don't become that agent that says, that's what my buyer said, because if you don't have it recorded, they're going to say, my agent told me that that's what I needed to do. Instead of getting it repaired, all I have to do is get the price reduced. I could do the repairs. I don't know how to do the repairs. So that's what's going to happen. Don't be that person. Great point. Don't renegotiate a price. Let the contract speak for the repairs. That's what it talks about. Inspection talks about inspections, not about renegotiating the price. If you want to renegotiate the price, make sure you tell your broker. I would not encourage it, but that's just a commercial from Mike. In response to Christina, overkill is way better than underkill. Amen to that. I bet Leonard would rather have the info twice rather than not at all. Completely agree. Great. Thank you, Lisa. And Robert, you're welcome. I'm sorry. Great questions. And that's why I went ahead and cheated as far as going in, because I love the contract and I knew you was going to run over. All right. So FHA financing, remember there's an addendum. You're going to have them sign it. Make sure you know what it says. If you have any questions, please, we'll address that, hopefully, if time permits, in the other class. We'll go over some of the most commonly used addendum. VA, remember that the property has to appraise, or, it needs to be renegotiated. Conventional loan, basically what that says is the mortgage company doesn't care how much a house is worth. They want to know that if it has value, if they're going to loan 80% on that. So again, it may be worth more, but they're going to make sure that it appraises for that price. Proration, that talks about the taxes. Sellers responsible for taxes from October 1 to the day they close. The buyer's given credit, but then they are responsible for the taxes following. So again, know that. If there's any questions, please call me. Risk of loss, this is something that says that prior to the closing, if something happens to the house, the seller has an obligation to keep homeowners insurance in force. Number one, because if something happens, insurance will bring it up to the same standard that it is now. Or if it is an as-is deal, or if it's a cash deal and something happens to the house, the purchaser may say, rather than you fix it, I've got people that can fix it. You give me the insurance proceeds, we'll rock on. So either way, it's written in there that that's how to be handled. Don't try to write something else in there. Systems and appurtenances. Just a tip, have the buyers and have the sellers read that. And if there's any questions, have them ask it at that time. I will tell you from experiences that this was what cost me the most money in real estate. Case in point, and I love everybody here. However, you women, y'all have an attention, or you have this attraction to master bedroom curtains, because the seller had a master bedroom curtain that matched the comforter. The purchaser's wife comes in and says, well, I love the curtains. When the closing, they're doing the walkthrough, the seller's taking the curtains down because it matched the comforter. The purchaser says, I bought the house because of that. So I would have to buy master bedroom curtains because I did a poor job of showing them what appurtenances are. Notice here it says window treatments. Right here, rods, everything else. Do not fall into that trap. Make sure that they read it. Make sure you know what it is. They're going to go ahead and look at it, and there's a place for them to initial. Make sure that they are aware of what they're initialing. Don't say click here, click here, click here. All right. The number 10 says that the seller is not withholding any information on homeowner association assessments, or if there's going to be a county assessment, that if they know it, they have to go ahead and tell it. The default, 11. I'm going to summarize this for you. The bozo no-no that I talked about. Remember, never write any additional provisions, anything about the home inspection. Number 2, never write anything about earnest money being refunded, because you have an obligation to either the seller or the buyer to work under their instructions, but it's their lawful instructions. Alabama license law is very specific on how earnest money is to be handled. So when you write in there that if this transaction fails to close due to no fault of the buyer, earnest money will be refunded. That is unlawful instructions. That will get people all mad. If you get an offer and it's your listing, strike it because it's unlawful. Alabama license law says the only way that earnest money can be distributed is with the mutual agreement or the signed agreement between the buyer and the seller. That's it. Doesn't matter what you write in Offer. Sometimes we think the more we write, the smarter we are. We're not. Sometimes less is best. And in this case, inspection. Never write anything in there about inspections. That includes waiving the inspection. That's another thing. If you have a disagreement with that, you can call me. I'll talk to you about the hassles and the issues about that. But make sure that you don't write anything about the inspection and about earnest money. Never write anything in there about earnest money, because no matter what you write in there, it doesn't matter. Doesn't matter. So that's what this says in default right here.
Is there a timeline on the earnest money to be delivered? And then can you say, okay, in Illinois, you had 24 hours after the signed contract.
Mhm.
You had 24 hours to get it to the listing company and the attorney and whoever title company. But if you didn't have it in that 24 hours, you could say, well, they're out of town, they're mailing it. And if both agents agreed, it was fine.
We have a question about earnest money, and where she was talking about in Illinois, they had a specific time frame. Alabama law says that all earnest money is to be turned over as soon as reasonably possible. And if it's cash, immediately. I wish there were timeframes in it. There's not. As soon as reasonably possible doesn't mean 2 weeks from now. If there is a delay in the earnest money, and let's say that somebody's writing a check for earnest money but says it's not going to be good until the 15th, make sure you write that into the additional provisions saying that earnest money to be collected at this time, because if the real estate commission comes and audits your file and they see in here that the offer was ratified on June the 3rd, but earnest money wasn't deposited until the 15th, and there's nothing written in there, they're going to raise their eyebrows. Don't do that.
And check with your broker, because a lot of brokers won't accept anything until the earnest money is checked.
So is the contract void?
Huh?
They just won't accept it
Like I made a note in the file.
because they don't want to audit it.
Envelope. It said it wasn't deposited
Make a copy.
because it was laid in the mail.
Make a copy. Question was if it was delayed in the mail, if it's your broker, if it's you. And one thing you got to remember too, that you're required to keep all files, all real estate files for 3 years. And that means, he or she that has the most pieces of paper generally win. In this case, what you want to do is if you ratify on the 3rd and you don't get the earnest money until the 15th, make a copy of it with the envelope and saying received on this date and put it in the file. That way you have explained something that was out of your control. If you don't, it's going to be hard for you to remember, oh yeah, that's what happened, and there's no validation to it.
What are they writing after this? We'll give you the earnest money.
And again, it's written in there on a certain time. That's another thing. I'll talk to you after the class and what I would do. So again, this talks about the earnest money, what can be done to it. Alabama license law addresses that specifically. Trust account, this talks about the earnest money to be deposited in either the listing company or the seller, the selling company, their trust account. Alabama license law is very specific. This talks about how earnest money is handled in a real estate transaction. You can explain it to them as far as saying, you write this, at the time of closing, you're given credit for this. The seller can be told the same way. This is being held in trust, and if when it closes, you'll be given credit for it on the closing disclosure. If you read that, that's what it's going to say. Paraphrase it into your own language. 13 is the alternative dispute resolution agreement by binding arbitration. Basically, this says we're not going to go to small claims court. We're going to handle everything through an arbitrator. That's what this says. Learn how to verbalize it, because if you read it, you're going to fall asleep halfway through it, and they've already fallen asleep. Learn how to say this. Just says basically everything will be handled through an arbitrator. Terminology, this is an explanation of what business day is when, if it says 5 days, it includes, gives the list of the holidays. Make sure this may not be come into play unless you're writing an offer on a specific holiday. So know what these things mean. Electronic signatures, this means that dot loop is acceptable. Also, there's something in there called a fax. Fax is, for most of you people, you don't know what it is, but this was where data was transmitted over something called phone lines, not cell towers, but it's still acceptable. One day, if you want to know, you people under 30, that I'll explain what a fax machine is. Okay, entire agreement. This talks about the contract. This says this contract together with any addendums constitutes the entire agreement. So you can't have one part and nobody has the other part. It has to be all of it. And the attorneys and or the lender needs to have all of it. Because then you're working off a different contract, and Alabama license law and the federal government through RESPA frown very hard on working off the different contracts. So do not fall into that trap. Make sure that everybody has every piece of paper. The additional provisions. Generally, the less you write in there, the better off you are. Number one, make sure that you write in there nothing about the inspection. Number two, make sure you write nothing about the earnest money. Those are addressed in either license law or in provisions of the contract. Now, talk to your lender, because a lot of people are waiving the appraisal contingency. People are wanting to say that, we're going to waive the appraisal contingency. Make sure your lender is good with that, because you may want it and the buyer may want it, but if they waive that contingency, that obligates them to make the difference up. And if they're not going to, or whatever, then if they don't have the capability, then your lender is going to say, I'm sorry, we're not going to lend money to it. Just because you waive it, and you're going to have a bunch of people that have their pooched out lips. Don't do that. Make sure you check with the lender. And if you do that, you tell the purchaser that if you waive this, yes, it's more attractive, but you're obligating yourself to more money. The witnessing, okay. If you are handwriting this, or if you're using that thing called a fax, and you did not see them sign it, don't witness it. You don't know it. Now, here's the little thing about professionalism. Seller has the opportunity to check one of these three boxes. The number one complaint that we are having right now, besides somebody being mean or whatever, is that I don't know if my offer was presented. I don't think my offer was presented. My buyer doesn't think that the offer's been presented. Listing agents, mark this. It's an easy way to go ahead and take care of that situation. Remember, you have not only a legal obligation, but you have an ethical obligation to present all offers. And if the buyer's agent asks you, you have an obligation to present a letter from the seller saying yes. Go ahead and stop that by just checking this box. Common courtesy. Do unto others as you would have them do unto you. If you have the listing, have your seller check it.
Reject and sign.
Exactly.
That's signing part.
Also, the binding date agreement. Let me stress to you, the binding date agreement doesn't make it that where they can't close. This means that this starts the time frame right here. The listing agent confirms that the contract was accepted and delivered to the parties, and the date to begin contract performance is. Basically, this says all the time frames, the blank that has blank days, the 5 days, when the listing agent signs it, that's when that was to start. It doesn't mean that this contract is not legal until that binding, the listing agent signs it. All this says is this is the time frame. Now, this is just sort of a tip. I see this going away because .loop electronically date timestamps everything. So this may go away, but don't think that just because the listing agent didn't sign it, that doesn't mean that it's not going to be enforceable. Let me go back to these questions.
If I got the buyer, they sign the purchaser, but if it's .loop, I don't put my signature on it.
You
So
can
I don't
go
sign it
ahead.
anywhere as
No.
a buyer's agent.
No, you can, remember, that's the listing agent that signs that.
Down at the bottom.
For the binding,
Right.
the binding
I'm the
date.
Purchaser, the witness. I mean, then as the buyer's agent, I don't sign it anywhere.
You don't witness it if it's not.
Yeah, it's already marked on that.
So
All right,
Don't witness it unless you actually witness it.
all right, let me,
it's not anywhere then.
I've got some questions. I want to go ahead and address that. You mentioned cash earnest money needs to be paid immediately. I thought we could only accept certified checks or money order for earnest money delivery. Tina, great question. Cash is still legal. You can do it. Your broker probably doesn't want you to do it. And what they will do is encourage you to go to one of these places to get a money order. So you can do that. But is cash legal? It is legal. It's not encouraged. So great questions. Are the addendums covered in the contracts too? I have it down for the 15th at 10 o'clock. Lisa, I think that's for your office. I'll be doing a contracts class. It may or may not. I'll make sure that I'll breeze through this and I'll address the addendums. Cash can be accepted, but immediately turned over to your broker in office. Yes, absolutely. As far as accepting cash is legal, but you're going to have to make sure that you turn it over immediately, not as soon as reasonably possible. And your broker is probably going to ask you to have them do a money order, take them to a place and spend $5 to get a money order. Is the estimated closing statement or the finance sales contract what we use to submit an offer? Okay. As far as what Alabama license law requires, number one, every offer has to be accompanied by an estimated closing statement, whether you're working with a buyer or a seller. There's one on there. There'll be another class that's being done on the estimated closing statement. But Alabama license law says you're to present whichever party that you're working with an estimated closing statement on any time that there's another offer to be made. So if it's a $500 difference, you still have to do one for the seller. And if your buyer made that, then you have to do one for that. Lisa never apologized working with one seller so far and the listing didn't sell and he didn't renew. I understand those things happen, but again, call me after and I'll be glad to explain, but an estimated closing statement has to be presented with every offer. Okay. Robert, thank you for attending. I'll send you a note. Melissa says, I'm having issues with listing agents. Oh, come on. With listing agents not signing the contract as rejected. They think that they can just call me or email me that which they accept another offer. What can you do? All you can do is stress to them and ask them to present that offer that shows a rejection. That's one of the professionalism tips that I wish I could convince everybody they need to, but the fact is, if never mind what somebody else does, if you have a listing, make sure that your seller signs that. Okay, so basically that's everything in there in the contracts. Again, this is something that is most misunderstood. You fill out this information, the agent and brokerage information, that gives the attorney permission for you to get the closing disclosure. So fill this information out as quickly as you can. Remember, if there is a blank, try to fill it out as much as possible. Also, if there is something that gives you problems on the finance sales contract, call me and I'll try to, you find a way to put it into human words as opposed to lawyerese, because your parties need to understand it. They are signing something. They're setting instructions for the mortgage company and the attorney to follow. All right, so with that, that's pretty much it. Got another question. Thank you, Lynn. I appreciate you attending. I know sometimes it's like drinking out of a fire hose, but the fact is that this contract, and we're going to go more into details because that's a complaint. People are saying that people are coming into the business. People have been in the business for a while, and they don't know how to write an offer. Remember, they don't write contracts, they write offers. Thank you, Lance. I appreciate it. Are there any questions or comments about the material? Remember, material. All hearts and minds clear. I'm going to be available for a few more minutes to answer any questions. I appreciate your patience with me. So if you have any questions, please feel free to ask. You can, let's see, when is the more detailed class? Look for it. I'm starting to work on the more detailed class. Also talk to your broker. I'll be glad to make a call or visit. Thank you, Tina. Via Zoom or to your office now to explain this. Again, I just want to go over the explanation of it. Your broker is going to have the final say so, but I'll be glad to help you in any way that I can. So talk to your broker about having me come out. With that, if all hearts and minds clear, we are free. I'll be here for a few more minutes. People, again, thank you for attending and thank y'all so much for being here. We are adjourned. Lisa, thank you so much for the kind words. Give me just a few minutes, but please feel free to give me a call and I'll be glad to explain those things. Bless your heart with your car issues, nothing more frustrating, but I'll talk to you real soon. Thank y'all, everybody. I'm here for a few more minutes.